next case on the calendar is Cindy Phillips Henry versus State Farm. And whenever counsel is ready. How much time would you like for rebuttal?
5 minutes, Your Honor.
All right, you may begin.
Good morning. My name is Chad Barr, and I represent the appellant in this case, Cindy Phillips Henry. We are here today asking the court to reverse the final judgment entered by the trial court in this case, which was following an order denying Ms. Henry's motion for a motion for leave to amend to add a claim for punitive damages. The easiest part about this appeal is the facts that precipitated the filing of this case in the first place. I'd like to give the court just a brief history of those facts to set up the context of the argument. In 2008, Ms. Henry was in an accident. She was insured by State Farm. Her policy included $10,000 of no-fault coverage and $10,000 of medical payments coverage. During the claim submission process, State Farm was notified several times that Ms. Phillips was missing work due to the accident. Medical bills were coming in, and those were paid under her no-fault coverage. And eventually, her no-fault coverage...
Did State Farm give the option of requesting reapportionment before the benefits had been exhausted to your client?
I saw that in State Farm's brief, and I went back to the record. It was argued at one of the hearings that that option was made, but there was no actual document in the court record that indicated that she was given that option. I don't think it matters, though. I think even if we stipulated that they gave her that option prior to benefits being exhausted on no fault, it wouldn't have changed the argument today or the argument before the trial court based on the Bennett case.
Well, are you saying that the Bennett case, as a matter of law, requires reapportionment so that the insured can get the fullest benefit of the policy benefits? Is that what you're saying?
Yeah, I think that essentially what we're saying is Holloway started the whole thing. The Holloway case in 1979 started the whole thing, saying that State Farm has a duty to reapportion benefits.
What about the provisions of the policy that say there is no coverage until the medical expense benefits of all no-fault coverage available from all sources has been exhausted? There are other provisions I could go into, but I don't think the Bennett case had a policy of insurance that was even in the record when they issued that opinion. So what about the provisions of the insurance policy itself that talk about reapportionment? Are those provisions valid and enforceable?
Well, they're valid and they're enforceable. The problem is State Farm's entire defense of this case is that reliance on our policy was the reasonable basis for us to deny the request for reapportionment.
Well, that's in conjunction with the other ruling from the what was it, the Third Circuit, which upheld the language in the amendatory endorsement. Is that correct?
I'm not sure what Your Honor is referring to, because there's no DCA case law that says State Farm doesn't have to reapportion benefits.
Well, Third Circuit Court in Florida upheld the language in the State Farm policy. You would agree with that, correct?
I don't have any issue with the fact that language is in State Farm's policy. What we need to focus on is the fact that this exact language has been in State Farm's policy since the Holloway case, and Holloway actually addressed the language in that order.
But if that's the case, and if State Farm did not have the requirement to reapportion benefits, how is it that State Farm acted in bad faith, and how is it that they acted willfully and wantonly or with reckless disregard of the insured's rights? I mean, I'm lost there.
Well, I disagree with Your Honor's assertion that they didn't have a duty because of what's in their policy. They absolutely did have a duty, and I want to go through that. The Holloway case
And
included,
just make sure you're saying that despite the language in the policy that says that there's no reapportionment, that they had a duty to reapportion anyway, because you said these policy provisions were valid and enforceable.
the policy does not say they do not have a duty to reapportion. I think that if
Well,
the
it
court's
said-
going to read that,
Wait a minute. It says there is no coverage until the medical expense benefits of all no-fault coverage available from all sources has been exhausted.
that was the exact language, policy language, that the court analyzed in Holloway when it said that they did have a duty to apportion the benefits in order to maximize recovery. That language was in Holloway. The court analyzed this same exact issue in Holloway based on that same exact policy language. So this policy language has been in State Farm's policy since the Holloway case.
Is there a difference between a request for reapportionment before the benefits are exhausted and a request for reapportionment after the benefits are exhausted?
Absolutely not, and that's
There's no difference?
no, and that's why it's important to understand that Holloway and Bennett, they live harmoniously together, and they address this issue from both sides. Holloway says that if the request is made pre-exhaustion, then they have to honor it. And so State Farm said, okay, well, if that's the law, let's go and let's deny reapportionment requests made after benefits are
But
exhausted.
they argue in this particular case that the request for reapportionment was made after the benefits.
It was made after exhaustion in Bennett.
But they gave the insured the option before the benefits had been exhausted to reapportion, and the insured didn't take them up on that offer.
Well, again, that was what was argued. There's no document in the record that's going to support that.
I don't know, what are we supposed to do with that argument then? Just ignore it?
No, but we look to Bennett, and Bennett says, because the request in Bennett was made after benefits were exhausted. The request to reapportion in Bennett was made after benefits were exhausted. So Holloway, the request was made before, and Bennett, the request was made after. So since 1991, State Farm has known that if a request is made to reapportion benefits, either pre-exhaustion or post-exhaustion, then you have to honor that request. And then we have to understand also, when we're asking for...
Really, if that's the case and there's a request for reapportionment, then this policy language is meaningless then.
It's not meaningless because if the benefits are reapportioned in order to maximize recovery, it doesn't change the effect of what the policy says.
Well,
PIP benefits are still going to be exhausted.
I don't understand, I don't see how you can interpret this any other, there is no coverage until the medical expense benefits of all no-fault coverage available from all sources has been exhausted. What does that mean to you?
It means the same thing that it meant to the court in Holloway in 1979. It means that
But in Holloway, they asked for the reapportionment beforehand, correct?
that's true.
And
That's
we
true.
didn't have that here, so that's...
But asking for reapportion doesn't change the effect of the policy language. All they're doing is shifting what was paid under MedPay to no fault, and from no fault to MedPay. The benefits are still exhausted under no fault, opening up coverage to MedPay. It's just a matter of what's paid under each one. And we have to look also, again, their primary defense in this case is reasonable belief that their policy doesn't require reapportion. The Holloway case, the Bennett case, the Howell-Demarest case, and the Swearingen case out of the Middle District, we have to see an express exclusion of the right to reapportion benefits. We don't see that. Reapportioning benefits does not change the effect of that policy language. And when they submitted this exact endorsement to the Office of Insurance Regulation, this didn't change. This language did not change. And if you look at what the Office of Insurance Regulation said, they said, we're not going to allow any amendment or change to your policy that limits an insured's ability to enjoy maximum recovery under combined coverages. That's what we're talking about in this case. Reapportioning benefits after they're exhausted or before they're exhausted doesn't change the net effect of what their policy says. No one's coming in here and saying we should strike the policy language. But it doesn't change the effect of that by requesting reapportionment. And that's what the gist of this case is, that from 1979, 1991, 1996,
If what you say is true, in State Farm, let's just assume gave the insured the option to reapportion before the benefits had been exhausted, and the insured didn't take them up on that offer, and then the benefits were exhausted, and then after the benefits were exhausted, then the insured came in and asked for reapportionment, and State Farm said we can't do it based on the policy language. How is it that State Farm acted willfully and wantonly or with reckless disregard of the insurer's rights? What did they do wrong?
well, There's all the evidence that we rely on is in the briefs, but there's four primary pieces of evidence that we want the court to focus on in making its decision. But first of all, it is our position firmly that they have ignored 35 years of case law saying that they have to reapportion. There's very important language in both Holloway and Bennett which talks about State Farm cannot take advantage of the nativities of their insureds. So regardless of whether they give them the option, it doesn't change, again.
But here, the issue in this particular case is whether there was a sufficient reasonable basis showing that there was an entitlement to plead a claim for punitive damages, right?
Correct.
It has to be willful and wanton misconduct, which I attach intent to, or reckless disregard.
Correct.
And based on these facts and circumstances, I'm having a difficult time determining whether either one of those requirements have been met, given the fact that in the record they're arguing that they gave the option to the insurer to reapportion before the benefits were exhausted. The insurer didn't take them up on that. Then after the benefits were exhausted, the request was made and they relied on the policy language.
And I think the important thing is that the court first realized in Howell Demarest that when you're dealing with a first party insured, a party that has purchased coverage under a policy, such as this situation where you've got MedPay and you've got PIP, there is nothing wrong, there's nothing that's going to change and the benefits are being paid if we allow the insured to reapportion their benefits. They're not left holding the bag. In this case, it's $1,200 versus $1,200 of unpaid work expense wages when there was still $7,000 worth of MedPay benefits available. Switching how those payments were made, reapportioning them, doesn't change anything about their policy.
Yet it changes the amount that the insurance company is obligated to pay in benefits, right?
But the court has been saying since 1979 that they have the duty to do that.
But if you look at the Bennett case, Bennett does make a distinction between, within the Holloway case, because I guess in Bennett, State Farm saying, hey, wait, in Holloway, they asked before, in Bennett, they asked after, and the court was unwilling to make that distinction. I understand that. But it also notes in the opinion, we note that the insurance policy in question is not part of the record on appeal. No issue is raised regarding limiting language which might require a different result than we've reached herein. So in this case, though, there's a policy that we have that says what it says. So
it says the same thing that it said in Holloway. If you look at Holloway, Holloway addresses the exact language.
But Holloway deals with asking beforehand. This, we're dealing with a case where this was, after the benefits were exhausted, she asked for the reapportionment. And if I go to Bennett, which was asking afterwards, the appellate court in Bennett didn't have the benefit of the policy, which had limiting language. And what we have here is a policy which appears to have limiting language. And so
what you would have to find is that there is something that State Farm would have to do that it wouldn't ordinarily have to do if it was required to reapportion benefits.
You're essentially saying that they have to put a specific provision in the policy that says we have no duty to reapportion, even if there's a request made.
And absolutely, because if it's not 100% clear, then it's construed against the drafter and in favor of coverage. That's the law in Florida. That's the law no matter what we're talking about when we're dealing with insurance policies. And it's not clear in this case. It's not 100% clear that they're saying we will not reapportion benefits.
what is unclear about, in all caps, there is no coverage until the medical expense benefit of all no-fault coverage available from all sources has been exhausted.
That effect doesn't change. That effect absolutely does not change if the benefits are simply reapportioned. If those unpaid, if sufficient benefits paid under PIP are exhausted or sent to MedPay and they're substituted with those unpaid wage expenses, PIP is still exhausted, therefore opening up coverage under MedPay. So that the courts, Holloway and Bennett and Howell Demarest were concerned with State Farm taking advantage of their insured's naiveties, their insured's unassurance about how policies work, how coverages work, and that's what we're dealing with in this case.
Okay, so let me see if I understand your position then. You're not taking issue with the policy language. You're not taking issue with specifically the amendatory endorsement 6910.3, but you are saying that State Farm is taking advantage of the naivety of the insured, even though it was clearly written in the policy, And because of that, they have engaged in willful, reckless conduct, which then entitles you to punitive damages. Is that correct?
Yeah, Judge, the court had the policy language in Howell Demarest as well. And in Howell Demarest...
We've already talked about that, okay? And you're not taking issue with the policy language, but you're taking issue with the interpretation of the policy language and how that was taking advantage of the insured. Is that correct? Even though the policy language is very clear and it's been laid out and it's been litigated, and there have been cases that have made decisions based upon whether or not there was a pre-notice or no pre-notice of the allocation. You're focusing entirely upon State Farm's conduct and saying State Farm knew what they were doing and wrote an ambiguous endorsement, and therefore they shouldn't be rewarded for that, correct?
Right. And it's the same endorsement that's been there since 1979 at a minimum. So there's nothing that's changed in their endorsement. The courts have said that this doesn't prevent reallocation. The Office of Insurance Regulations has said we're not going to prevent insureds from enjoying maximum recovery under combined coverages.
This part of the policy say limit of liability, medical payment coverage, and that is that excess over and shall not pay any medical expenses paid or payable under any no-fault coverage, or which would otherwise be payable except for any no-fault deductible or the amount of workers' compensation benefits, which is not applicable here. What does that mean?
It's all going to the same concept, which is that the legislature at some point promulgated some concept that PIP is primary. Okay, PIP is primary, and they're discussed in those three cases that I keep bringing up, this concept of PIP is primary, and how it's an ambiguous concept that allows insurance companies to prey on their insureds when there's combined coverages purchased in this case. So nothing changes. If those unpaid wages are substituted as PIP payments, and then those medical payments are then that they took out of PIP are paid under MedPay, there's nothing that changes in State Farm's position. PIP is still exhausted, and now MedPay coverage is now available. They've been doing this, and they've been changing how they do it since 1979. They were told you can't do it if it's requested before exhaustion. In Bennett, they were told you can't do it if it was requested after exhaustion. And in Howell Demarest, the court simply said, they do have a duty. The court said they have a duty.
Okay, what is your position if the policy says, in plain language, State Farm has no duty to apportion?
The first hurdle would be State Farm getting that past the Office of Insurance Regulation. And if you look at the letters...
Let's assume the policy says that. You're saying that would not be an enforceable provision in the policy?
I don't think it would be. Obviously it's not the language in this case, but I don't think it would be based on public policy arguments that not necessarily prepared to make and provide support for, but I don't think it would be enforceable under that concept, and I don't think it would get past the Office of Insurance Regulation. If you look closely at what they said with respect to this endorsement, they can't do it. They can't limit coverage under combined coverages. They just can't do it. And so they've changed their positions. From 2002 to 2014, they were doing this.
So really, MedPay is really not excess coverage. It's just all lumped together with the PIP, right? Again,
my focus is really that PIP does still exhaust, and MedPay doesn't kick in until after PIP exhausts, but they're just using different bills to satisfy the PIP.
But it seems to me that if we accept your argument, basically what you're saying is, MedPay is not excess coverage. It's just lumped in with the PIP benefits. And if you've got all these bills and it's covered under both PIP and MedPay, regardless of what the MedPay provisions are, that you have to pay it anyway and you have to reapportion and all that. That's what you're saying, I think.
I'm saying that PIP still exhausts, which then opens up the door for medical payments coverage. It's just a matter of what's paid under PIP.
Wages are not MedPay meet the MedPay coverage. Wages are not.
Correct.
Wages come in under PIP.
Correct. I'll save the rest of my time for rebuttal. Thank you.
May it please the court, Paul Nettleton of Carlton Fields on behalf of the Applee State Farm Mutual. What I'd like to do, Your Honor, if I could, is just briefly outline there are two reasons we believe this court should affirm the trial court's summary judgment under review and address them first in reverse order because counsel didn't mention the other, and I don't want it to get lost in the shuffle here. It's our position that this court can affirm this final judgment without even reaching these punitive damages.
Are you going to talk about the fact that there's no compensatory damages? And
Correct, Your Honor.
All right. Well, what about I'm more interested in the provisions of the insurance policy, actually. I understand that argument, well, there's no compensatory damage, therefore you can't have punitive damages.
Correct, because of the language of the statute itself that requires it.
You know, we have these provisions in the insurance policy, and their argument is that, well, it doesn't. This language really doesn't change anything. You have a duty to reapportion whether the request is made before exhaustion or afterwards. And then they cite these cases that basically say there is a duty to do that, although one of the cases says that the insurance policy is not in the record, and we don't know what the provisions of the insurance policy are. Do you agree with that argument, that there's this duty to reapportion regardless of what the policy says?
No, of course not, Your Honor, because that's the starting place for what are the duties and responsibilities and obligations of the parties is defined by the language of the contract. You've got to start with the language of the contract. Counsel's statement that the policy was always the same since 1979, absolutely not true. That's contrary to the record in this case. The record shows that this particular policy language from 6910 was first approved by OIR and implemented by State Farm in 2002. And the reason is important here of why that policy language was implemented. It was implemented because prior to 2002, there was a provision in the PIP statute referred to as the MedPay provision that coordinated PIP and MedPay, and there were cases out there that would disregard language in the MedPay provisions of the statute, of the policy, because they said the statute overrode it. In 2001, the legislature repealed that provision in the PIP statute. So as of 2001, once that repeal took effect, the policy language of the MedPay coverage is purely contractual. It has no overtones of statutory implication here. And so you've got to look at the policy language here. And that's the starting point. And the policy language that you read, Your Honor, and especially the last provision is just key. Not only is PIP primary, which was true back in the Holloway days. If you look at the Holloway decision, though, it was struggling what does primary mean for PIP. It wasn't the same provisions at all. In this case, at least 3 different times in this policy under the MedPay provisions, we've got it in the insuring agreement, we've got it in the limits of liability provision, and the exclusions.
If that's the case, then why did State Farm, just out of the goodness of their heart, offer to reapportion before the benefits had been exhausted? Why would you do that unless you felt you had an obligation to do that?
Because there were people out there arguing that, Your Honor, and so you're right. I don't believe the policy would require that. However, in order to comply with the policy, the language, what State Farm would offer whenever a PIP claim came in since 2002 was to allow the insured to reserve whatever portion of the PIP coverage they wanted for loss.
If the policy says you don't have to do that, and you may end up paying more benefits than that you're actually entitled to under the provisions of the policy, you're saying you just, out of the goodness of your heart, just doing that to help the insured?
Yes, Your Honor, to maximize their benefits under the policy, and there's reasons for doing it that way versus allocation up front and reallocation on the back end are two completely different things.
So you're saying there's a duty to maximize the benefits under the policy. So are you saying that there's a duty on the part of State Farm to do it pre-exhaustion?
Under the language of the policy, there's not. They offer, and here's why, Your Honor, because what the offer is to allow them the option of reserving, which State Farm will then treat as exhaustion up to the amount of that reservation. So it's still adhering to its policy language.
You said that you thought that there was a duty to maximize the benefits under the policy. That's a legal duty.
It's a duty to maximize the benefits available under the policy. They have to be available under the policy, which gets you back to the language of the policy again. And the policy here restricts when MedPay is payable. And it's in addition to the excess language, Your Honor, the final stuff that you read says that it will not pay expenses paid or payable.
Do you have a duty to make that offer pre-exhaustion or not?
I don't believe there is a duty to make that offer.
If they request the reapportionment pre-exhaustion, are you obligated to comply with that request?
Only through some kind of estoppel type theory, Your Honor. It's not, the policy would not require it.
I'm not talking about that.
The
About
policy
estoppel.
does not, I would say the policy does not require, there's no duty under the policy to reserve PIP for lost wages. State Farm offers that as a benefit to its policyholders if they wish to do it up front to avoid, as we mentioned, one of the issues in this thing that's in the record is to avoid manipulation of the coverage on the back end. That is, once these policy things are, the medical expenses are paid under PIP, you can come back, under MedPay, you're limited to 3 years from the date of the accident. There's no limitation on PIP coverage. So what happens is...
I mean, I understand that PIP coverage is required. This MedPay is something that you buy in addition, right?
Correct. It's optional.
But in other words, you're saying, you seem to be saying that there may be a duty on State Farm's part to maximize the benefits under the policy for the benefit of the insured, yet then you're saying under the provisions of the policy you don't have any obligation to do this apportionment analysis.
Both of those are correct, Your Honor.
I don't know if that makes a lot of sense to me.
The language of the policy would not require State Farm to offer to allow them to reserve it up front. However, State Farm does that.
The cases that we've discussed, do they require it?
I'm sorry?
Do the holdings of the cases that we've discussed require it? Bennett and some of the other cases, Holloway, that we've discussed?
No, Your Honor. And first of all, let me address Holloway and Hal Demarest, because those are easy. Those are not reapportionment cases. Those are both cases in which the insured requested upfront, before any benefits were paid, to reserve those benefits for purposes of lost wages. That's not our situation here.
You can say it's not, that sounds like an apportionment issue to me, but you're saying it's just a reservation to reserve benefits from one to the others. I don't know if that's, anyway, go ahead.
Sorry, Your Honor. Well, there is a distinction, and in fact, if you look at Hal Demarest, when it's interpreting its previous Holloway decision, it specifically says, we never said in Holloway that you've got to reapportion after the fact. It said there has to be a prior request. And prior to what? Well, prior to paying the benefits under the PIP policy. I would submit that's what Judge Lambert said in his dissent and how he interpreted Hal Demarest as well in the underlying PIP case here. The Bennett case, Your Honor.
Okay, but does that then, if there's a request made prior to exhaustion, does that create a duty on the part of the insurance carrier to comply with that and to reapportion the benefits? Is there a legal duty to do that?
I want to stay away from reapportion as opposed to apportion up front. If there's a request
okay, we'll go with that.
There is no duty under the language of the policy. As I said, State Farm has a practice of offering that.
Is there a duty created in the law based on the decisions that we've already discussed?
No, because we're dealing with different policy language, Your Honor. We're dealing with different policy language that was involved in this case. The only decision prior to the claims decision in this case, the only reported decision out there was from Judge Tom Coleman in the Third Circuit, which went through this entire argument. It's the only decision that was dealing with this policy language under the current statutory regime that we were dealing with in this case, and it agreed with, and Judge Coleman agreed with State Farm. We fast forward to this case. As we know, when it went up on appeal to the Fifth Judicial Circuit in its appellate capacity, State Farm came out on the short end of that with a 2-1 decision. But Judge Lambert wrote a lengthy dissent agreeing essentially with State Farm's position throughout.
That basically had to do with the bad faith issue. What did State Farm do that was in bad faith? They just simply relied on the policy. Now, what we're talking about now, we're kind of past that because the panel in that case, the majority said that there was a basis for the bad faith action. The dissent said no. So we're kind of past that. Now we're talking about, is there a proper basis, reasonable basis in the record to establish a claim for pleading punitive damages, right?
Correct, Your Honor. That's really what we're here about, and I feel like we've been arguing the original
Yeah,
case.
I'm trying to determine what State Farm did that was willful or wanton or in reckless disregard when there was no duty on the part of State Farm to readjust, or you can call it reapportion or whatever. That's the problem I've been having. As far as your issue as to compensatory damages, why wouldn't there be compensatory damages if there's a proper basis for a bad faith cause of action?
Well, plaintiff has conceded repeatedly here there are no compensatory damages, so we don't get to whether they are or not existing. They've conceded that issue. My point is that under the statute specifically says that any person who is damaged by a violation of one of the provisions. So the express language of the statute requires actual compensatory damages. That's what the 2nd District held, which was approved by the Florida Supreme Court.
Right. But we're talking about a bad faith cause of action here.
Correct, Your Honor. Exactly. Under this bad faith statute, 624.
If the jury finds that State Farm did act in bad faith, is there entitlement to at least nominal damages?
No. That's exactly what the 2nd District held in the second Conquest versus Auto Owners. That was argued, and the court said nominal damages.
If there was a basis for nominal damages, then there would be a basis for punitive damages, right?
Arguably.
Well, you say arguably. I see.
But we don't even get there because you don't have a right to nominal damages under the bad faith statute. So, but I want to kind of bring us back to, I guess, where we are. I didn't mean to start re-arguing the underlying case, which is whether or not there is a duty.
The bottom line is, if we affirm the trial court, basically that just says there's no reasonable basis for a claim for punitive damages. Then the trial court can carry on with whatever it was doing in the bad faith cause of action, right?
Well, the bad faith cause of action was over, Your Honor, because they have no compensatory damages.
Well, has the trial court specifically ruled that?
Yes, it's final summary judgment, Your Honor. So there's no compensatory damages. They convinced presumably, we don't know what the judge was thinking, but allowed the case to proceed for 3 years on the basis of trying to get punitive damages into the case. There was 3 years of discovery, 3 motions addressing this issue, and the judge each time determined that they failed to make a reasonable showing for a reasonable basis in the evidence or what they proffered that punitives would be awarded.
Okay, if you're correct in saying that the underlying bad faith cause of action has gone away and doesn't exist anymore, then this issue is basically moot then. So why are we here on this appeal?
Well, because they're arguing that the court erred in denying their motion to add punitive damages under the Scott versus Progressive and Hal Demarest 4th District.
Your argument is that I thought you said that the bad faith, well, this is basically connected. The punitive damages are in the bad faith cause of action. You're saying there is no such thing as a bad faith cause of action because the lower court did away with that.
Well, granted summary judgment because there's no compensatories and they've been unable to establish a basis for punitives, even if they could proceed solely on punitive damages.
So you're saying it would have to go back to the trial court for the trial court to make a ruling, and if there's no basis for punitive damages and the bad faith cause of action is gone, or does this end it right here?
This ends it right here. The judge has already made that decision that there's no basis for punitive. That's the issue currently before this court, is whether that was correct or not. And we submit it was entirely correct. And again, not getting back to whether or not the policy precluded or required or not, the question really is there sufficient showing in the evidence that State Farm's position in that regard was taken maliciously and in reckless disregard? And that's where it's key to look at what the law was at the time. And we get Judge Coleman's decision out of the Third Judicial Circuit, which said we were absolutely right. The exact same arguments you can see in the opinion were addressed in that case. Addressed the fact that the 6910 endorsement developed after the removal of the language from the PIP statute, referenced the Bennett case, did not by name, but said one of the cases the other side relied on, said, as Your Honor mentioned, that the policy was not in the record and the language of the policy may have made a difference. Here, the language of the policy made a difference to Judge Coleman, made a difference to Judge Lambert, who looked at this very same issue. And it's our position that to even suggest that there's enough here just based on what State Farm's coverage position was, To say that that's enough to get to a jury is tantamount to saying that those opinions issued by those judges were malicious and in bad faith and so forth. I mean, how can State Farm be accused of being malicious, of taking a position in reckless disregard, of taking a position that two judges have agreed with? It's untenable.
And you have to take Judge Lambert's dissent and disregard the majority opinion.
Understood, Your Honor.
Do that, but in any event. All right,
And again, it's not a question of what's the right decision. We accept that
Right.
we lost that issue in the underlying case here, but it's still a question of, was the position being taken maliciously and in reckless disregard? And given the state of the law, I don't think, as the lower court decided, that there was not a sufficient showing that maliciousness or reckless disregard here. So we would submit it should be affirmed on that basis. As I said, the policy language changed in 2001. That's even established by their own expert affidavit, which we submit was simply legal conclusions and restating the proffer. Counsel mentioned the OIR letters again. As we set forth in our brief, those have no application to the issues involved here. They weren't addressing the language. In fact, the Office of Insurance Regulation approved the very language that we're talking about here. And it's belt, suspenders, and extra suspenders in the language of the policy here that says we will not pay under MedPay any medical expenses that have been paid or payable under no fault. Here it wasn't only just payable, it was already paid. So the language of the policy, it doesn't expressly say you can't reallocate, but the intent is very clear. And all the evidence in the case showed that State Farm was acting on the assumption that that was the language, that was the intent of the language. Judge Coleman agreed with it, Judge Lambert agreed with it. How can it be malicious? How can that give rise to a punitive damages claim? So we would ask that the court affirm the final judgment below. Thank you, Your Honor.
About a minute and a half.
I recognize that I'm about out of time, but there's just a couple of things.
Would you address the issue raised by opposing counsel that our decision in this case concerning the punitive damage issue ends the case once and for all?
Yeah, I would agree with that. I think that was stipulated too. So basically, you don't have to have compensatory damages if there's a pending claim for punitives. Okay, so in this case, because the court did not allow our claim for punitive damages and there's no compensatory damages, the bad faith claim couldn't survive that order.
If there's no basis for compensatory damages, how can you have a claim for punitive damages?
Well, that's all set forth in the briefs, and I don't think that even Mr. Nettleton would disagree with me that under Hal Demarest and the progeny of cases dealing with this issue, if there's a claim for punitive damages, it's not appropriate to enter summary judgment just because there's no compensatory damages. So that's not necessarily an issue. But I want to just read real quickly from the Swearingen case from the Middle District, and they analyzed Mr. Nettleton's argument to a T, and they said that State Farm argues that Bennett is distinguishable, because the Second District did not examine the policy and did not address any potential limiting language. While this is true, Bennett supports Swearingen's claims unless the exclusionary language of our policy clearly precludes it. And then it goes on to cite to the Florida Supreme Court case.
I just want to make sure I understand your argument on the compensatory damages issue. According to opposing counsel, you stipulated there are no compensatory damages. The law generally requires that you can't have punitive damages unless you have compensatory damages. So if we say you have a basis for punitive damages in this case, what is your basis for proceeding in the trial court then?
That's not an issue on appeal, because the only reason why summary judgment was entered was because the punitive damage claim wasn't allowed to proceed. If the punitive damage claim was allowed to proceed, there wouldn't have been a summary judgment entered, and we wouldn't be there'd be no appeal on that issue. So that's not anything that I think that we disagree on. And it didn't sound like he disagreed with it. It sounded like he was saying exactly what I'm saying. The only reason why that was mentioned was because we should have a punitive damage claim, and that would have precluded the summary judgment.
One of his arguments in this case is you have no compensatory damages, therefore you have no claim for punitive damages. Case ended. That's it. Over and done.
And no, if there was a claim for punitive...
He just argued that when he was up here.
He argued that because the punitive damage claim wasn't allowed to proceed. The cases that we cite in our brief make it clear that if there's a punitive damage claim pending, even if there's no compensatory damages, that claim can still survive, regardless of the fact that there's no compensatory damages. So we've
So
briefed
you're
that issue.
you're saying that the state of the law is that you don't, in this particular case, you don't need a claim for, or basis for compensatory damages. You can just go in and sue for punitive damages without a basis for compensatory damages.
We had our bad faith claim, and then because we sought leave to amend, if there's no punitive damages, then summary judgment is appropriate. But if there's punitive damages pending, then the claim still survives.
All right.
Thank you, you're out of time.
Thank you.